Hearing in the appeal Elefterescu against Royal College of Veterinary Surgeons.
Yes. Good morning.
My Lords, I have the here on behalf of the appellant in this matter, and my learned friend, Mr. David Bradley, appears.
Right, thank you.
This is an appeal brought as of right pursuant to Section 17 of the Veterinary Surgeons Act of 1966. And my Lords, I would respectfully assume that you've received the relevant paperwork.
Yes, and you could take it that we have read all of the papers, including your very helpful submissions on either side, so we're reasonably familiar with the background.
My Lords, in which case, just a few words by way of introduction. The essential premise that is made in this appeal is to raise the issue as to the way that judgments are formed or had been formed about the appellant in the context of the working environment in which he was in. And put shortly, it is this. The most serious matter of those allegations that he was faced with, in my submission, related to his treatment and conduct in respect of a particular animal subject of charge 4, known as Lucy Allen.
Yes.
It seems to me that unless I am able to persuade the court that the manner in which that most serious issue had been dealt with, which also related to clinical competence and also issues of honesty, then the other matters are of less importance. And so, for the relatively short time I seek to engage with you this morning, I wish to focus, if I may, on that context.
Yes.
Do I understand that that you're saying that if you don't persuade us in relation to Lucy Allen, then your appeal is not going to prevail or cannot prevail?
No, my Lord. What I'm saying is that in terms of my submissions to you orally, I'm going to take my time to focus on those matters.
I see.
And insofar as the other issues have been dealt with in my skeleton, I wouldn't seek to make further oral submissions to you on that regard. Put shortly, the key premise that I advance is that the panel dealing with this matter on behalf of the RCVS formed a certain view of the appellant in regard to his treatment based on the notion that he was solely responsible for decisions around treatment of this animal. And what I'm looking to advance before you is that the context in which those decisions had come to be made was at the end of a series of decisions and actions which had been taken by other practitioners within the service, within the particular veterinary practice, such that whilst it is accepted that in terms of the surgery, competence of that was rightly called into question, there was a particular issue around the way that the charges or the allegations were put against the appellant. And in particular, the allegation that in carrying out the surgery, he'd carried out an inadequate examination investigation into the possibility of a cranial cruciate ligament rupture and or failed to record such an examination. Just focusing on that point, the material which I set out in my written case sought to identify the fact that there had been a number of vets that had seen this animal prior to the suggestion that the appellant should perform surgery. And insofar as complaint was made of the appellant as to certain steps that he should have taken, including the use of X-rays, etc., that similar decisions and recommendations to the owner had been made by other vets within the practice, and also in the absence of such radiological investigations. So to that extent, I was seeking to impress that he was effectively being judged for not having done something which others who had made similar recommendations to the others, to the owner,
Had not considered necessary.
There is also it seemed to me, and I used the word profound in my written submissions and came back to look at it and thought, well, is it the right word? But it did seem to me to be a fair way to describe what had happened, because the college found, the panel found that in respect of failings on behalf of the appellant, for example, that he'd failed to adequately assess Lucy's condition because the X-rays taken on the 2nd of December 2015 did not demonstrate the radiological signs of rupture of the ligament. My submission is that's fundamentally flawed because the notes themselves revealed that the animal at that stage had not been recorded as having an issue with the ligament. In fact, that had resolved sometime later, and the notes record that on December the 16th, a vet had recorded that the animal was no longer lame in that regard, and was, on the 15th, and was walking fine.
Sorry, could you just point me to the bit of the decision which you say is in error?
If we go to the record of file 1, my lord, and if we go behind tab 1, page 15, paragraph 48.
Yes.
So the paragraph reads, the college's concerns are as follows, that the respondent, A, carried out an adequate examination investigation into the possibility of a cranial cruciate ligament rupture, and or failed to record such an examination, and then B, failed to adequately assess Lucy's condition. And there's a reference there at 4B1 to the fact that the X-rays taken on the 2nd of December...
Do you have an electronic page number for that, please?
My lord, I regret that I don't.
602. 602, thank you. Yes? Sorry, which paragraph are you referring to?
It's 4B1.
4B1.
48B1.
48B1, so sorry. Yes.
Don't think that's 602.
It's decision of the disciplinary committee as to facts.
It's 25, I'm sorry.
25, thank you. Thank you very much. Thank you. 48B2, right.
48B1, my lord.
B1, right. Before we get too deeply embroiled in this,
Yes.
do I understand your case to be that all the other charges, if I can put it that way, against your client would not have constituted a basis for his removal from the register, or however it's put? I mean, this is the pivotal charge against him. Yeah. Okay, right.
Sorry, you're not. Are you not? You're saying all the other charges. I mean, where are we left? I mean, if you succeed on this charge, where does that leave the decision?
Where we're left is that there is also a dishonesty allegation in respect of the record keeping.
Yes.
And that clearly is a serious matter also.
And one of the other animals.
So sorry, my lord, I didn't hear you.
One of the other animals.
And one of the other animals.
Yes, that's right. In terms of Storm and Sampson, the two cats. And I make submissions in that in respect of the extent to which dishonesty would apply in the particular circumstances in which those notes came to be created. My Lord, that relates to a lady who was a
Yes, I mean, I read the point, but I assume you're still, you need to attack that finding.
Yes, yes, I do.
You'll come to that, no doubt.
Yes, I will.
Yes, good.
I will.
But as far as this one is concerned, this is the college's concerns about the position of the X-rays on the 2nd of December, and you're saying that there was a finding relating to those which you attack, is there? Yes,
Because the findings which I refer to is paragraph 58.
58.
So sorry. So the college's concerns, I take you to paragraph 48. The contentions are then also set out. The findings in respect of that, in finding those charges proven, is at paragraph 59, so sorry. The committee found no evidence of pre-planning and no discussions of the risk of the operation. Although the respondent conceded there were problems with the surgery, there was no evidence he'd taken any steps to carry out revision surgery that should best have been done straight away. And so I'm concerned essentially, firstly, with that first issue around no evidence of pre-planning and no discussions of the risk of the operation. Now that takes us back to how it was that the appellant had come to do this surgery in the first place, and the absence of those pre-operative radiographs and his failure to have done it. But there was a reference to that, first of all, on the basis that, and it is confusing, that the x-rays taken on the 2nd of December did not demonstrate the radiological signs of rupture of the ligament. Well, you wouldn't expect that it would have done, and therefore it was confusing and unhelpful to have advanced that before the panel, that it was a matter which they could consider as demonstrating that the appellant hadn't taken the appropriate steps.
But hasn't that got to be seen in the context of the other points made? Because, as I understand it, the concern as expressed is that the X-ray that was taken showed no problem, and there was no subsequent X-ray before the operation.
Yes.
Isn't that the point that they're making?
That would have been the point had it stayed there, except that, as I identify in my written case, what then happened was that in the course of presenting this before the panel, there was, and I say it was a purely innocent error, but there seemed to have been some confusion around there being a second, actually some form of preoperative X-ray having been taken either on the 21st or the 18th of December, respectively.
But where's the finding about that?
The finding about that is actually in the it's paragraph 54. So at paragraph 54, and I'm so sorry I don't have the electronic reference to you.
That's all right.
Thank you. The committee also took into account the evidence of Professor Comerford. She concurred with Mr. Farrell, and then they say, with Mr. Farrell's observations, in particular, drew attention to the need for detailed preoperative planning, including recent X-rays, as follows, and noted that Lucy Allen did not have the diagnostic signs as evidenced by the radiograph on the 21st of December 2015 of a cranial cruciate ligament rupture. Nor was there a clinical examination with notes regarding assessment of pain, etc.
When was the operation done?
That was done in March 20. It was done in February 2016.
Yes.
So essentially, what the panel, what the committee found that it was being invited to do was to make a judgment that the appellant had in fact referred to a radiograph that hadn't been taken on the 21st of December 2015, and that radiograph did not show any evidence of there being a cranial cruciate ligament rupture. And that's why I say that there was no X-ray taken on that date. And prior to that time, when the matter had been referred to the appellant for him to take surgery, to undertake the surgery, it was being advocated that he should do that in the absence of having conducted that preoperative examination and that preoperative investigation.
Yeah, I mean, this is a point that's sort of summarised in pages 16 and 17 of your case, isn't it, at paragraph 23. There's this confusion about the existence of an X-ray on the 21st. And then you say at 27, the three experienced professionals have been advocating surgery in the absence of such an X-ray.
That's right. And that is evidenced in the notes, and the references to those notes I included in my submissions.
Yeah.
Now,
I mean, forgive me, I'm an ignorant. I mean, should he have done the operation? I mean, forget about the other three professionals. Should he have done the operation without an X-ray?
I believe that in his evidence, he couldn't, he would accept that he should have done an X-ray.
Yeah.
And so it may not be, indeed, not attractive, but it's a reality that when such judgments are being made about the clinical competence and what actually happens in practice in these environments, of course, it's right that the standards are high and there's a certain degree of a counsel of perfection. But it's also fair that when a practitioner is being judged for such failings, that there should be some recognition of actually what happens on the ground. And what happens on the ground in this situation, respectfully from my reading of the notes, is that three other vets come into contact. They do a particular test that doesn't involve preoperative X-rays. They all say to the owner and to each other, this animal requires surgery, in the absence of undertaking the X-rays. Now, that doesn't make it right, but that's what happens. The owner is encouraged, in my respectful submission, to do that. And it's also important that when, and I don't need to name individuals in that regard, but when recommendations are being made to the appellant as to the fact that he should conduct the operation, that there is similarly not sort of pressing or in any sort of mention, oh yes, but before you go ahead and do this, we're going to make sure, because we're going to carry out and make sure that there's a preoperative X-ray done. And that then takes me, if I may, to the evidence that should have been obtained and hadn't been obtained, and when it was obtained, I see from the record that efforts were properly made to put it before the committee, but of course the difficulty is that the committee don't say what they thought of it or what they took of it, and whether they even read it and what weight they gave it. But it plainly was relevant to the context in which this had happened, because the crucial thing is that, and I set out the note at page 19, is that a young lady said that she couldn't remember the details, but remember that the appellant had concerns. Now, that next sentence clearly may be misremembered, but it's the point about not being straightforward. And it seemed to her that...
Sorry, which one are you reading about now?
It's page...
Emily, is it? Or
Yes, it's
page 19.
Yes. It's the fact that there was a recollection that there had been concerns raised by the appellant about the procedure. And insofar as this particular witness potentially recalled, that there had been a certain amount of pressure being put on the appellant to get the operation started. She recalled that the individual said that time was getting on, the appellant needed to start the operation, and doesn't recall gentlemen having looked at any x-rays.
What were the x-rays
itself.
there? I mean, the concern there was not that there weren't any x-rays, but that the x-rays showed that the tear was not straightforward. Which x-ray was that?
Well, this is the difficulty. There is no x-ray. So insofar as she's referring to an x-ray, we're not assisted. But on the other hand, I was seeking to rely on it to show that her recollection that there had been some discussion between the appellant and the principal at the practice. And to that extent, it corroborated what the appellant had said, which was that he had tried to engage the principal in the discussion about the procedure prior to the undertaking.
It's difficult to put much weight on Emily's recollections if she thought there was an x-ray and discussion of it. In fact, there wasn't any x-ray.
All the more reason for... I mean, of course, this information was obtained very late in the day, not until May 2018 when the proceedings had actually started. The respondents will say that they had... that the nurses hadn't come forward at the relevant time and therefore their evidence hadn't been obtained. But it does demonstrate the point that there was a certain amount of confusion as to who had said what to how. What I sought to rely on was the extent to which the appellant would say, and this seemed to support that he had tried to engage the principal with a discussion about whether or not and how to carry on with this particular procedure. And so to that extent, there was a degree of corroboration. And there was also the other point about photographs having been taken, which is something, again, that the appellant sought to rely on. And so I don't think I can really take it much more. It is the fact that, in my submission, that the committee had misunderstood the evidence.
Could I just be clear as to the actual sequence, as in your submission it happened? Which x-rays were taken?
The last x-ray was taken on the 2nd of December, according to the clinical records. On the 2nd of December, x-rays were taken. They didn't show any evidence of cruciate ligament damage. The animal had sort of got better, if I can put it that way, although there had been some discussion about surgery because the dog was perceived to be overweight. The notes show that around December the 15th, the dog was signed off as clear, no other signs of lameness. And then on the 16th, she jumped out of a car. Jumped out of a car, did some damage, and again...
To the same leg?
It is the same leg. Can I have that checked a moment, my lord? Sorry, I can check. It is the same leg. Thank you.
was the same leg.
Same leg.
So the 16th, it jumped out of the car.
Particularly jumped out of a car, and it's then showing signs of cruciate ligament damage. The recommendation is again made that the animal should have surgery in the absence of any preoperative x-rays having been taken.
And the x-ray was taken after the operation?
After the operation.
How was the damage to the cruciate ligament diagnosed, if not by X-ray?
By something called the draw test. And the clinical records show that each of the three practitioners involved had all used this same draw test.
What's a draw test?
It's something to do with the way that they hold onto the animal and move, flex. It's purely done by examining the animal by hand, sort of thing. It doesn't involve any radiological investigation. So as a consequence of the three having done that, the conclusion is that the animal should have surgery.
The conclusion was reached by 3 vets that the animal should have surgery.
The clinical records show that there were certain discussions being taken as to the principal in particular is recorded as having proposed that that there should be some efforts made to find a vet that can undertake the surgery because costs were going to be a factor. The decision was taken to wait until the appellant, who was still fairly new to the organisation, arrived at this particular branch office, if I can call it that, and then he would then undertake the surgery. And that's what he did.
Right.
Now, the other, in my respectful submission, most material allegation of dishonesty also arose in relation to charges 2 and 3. And this involved the failure to fully examine or to record an examination that hadn't or had not taken place of 2 cats that belonged to the cattery nurse. My submission is sort of summed up again in paragraph 53 of my submissions on page 24 of my written case. And the starting point for this is that the lady involved, who was an experienced cattery nurse, these were her own animals. She had administered the pre-med. She was fully aware of the health and condition of the animals. It's a difficult situation because the appellant carried out this procedure to castrate both of the cats in a relative sort of straightforward sort of way because it was an ad hoc arrangement that had been made with the cattery nurse. He made his notes. He said that he had done some sort of examination. Yes, it could have been absolutely perfect. It could have been exactly fully compliant with best practice and actually appropriate practice. But again, the context in which this was done and the context in which the notes had failed to be recorded, in my respectful submission, the committee did not have due regard, again, to the circumstances. And so insofar as applying the IGEN test of dishonesty, my submission would be that that applying that test fairly, the first would be that the appellant fairly believed that he had undertaken a reasonable or appropriate examination of the animals in the circumstances that they were being brought to him by an experienced veterinary nurse, the owner of the animals, that she had herself given them the pre-med and sedated them, that she was fully aware of their health and condition. And she was perfectly content to sedate them, pre-med them, and present them for surgery.
I suspect that the more serious aspect of this is the allegation that he failed, or that he made dishonest and or misleading entries in the clinical records.
And that was very confusing, in terms of what he had or hadn't done, because the appellant said that he had made a record, he'd made reference, in two ways. He'd used a cut and paste approach. He said he hadn't actually been able to complete making his notes. He'd been challenged by the cattery nurse, who said that there were things in there that he plainly hadn't done, and he said the notes weren't finished. And by the time he got to the end, he said, albeit briefly, such notes as he had included was a fairly cursory, but was an examination that he had carried out. And he spoke of the fact that the cattery nurse herself had had a discussion with him about what the condition of the cats was, and they'd agreed to change the number, which evidenced how well or how unfit the animal was. And so my submission is that in the context in which this occurred, that it was not the case that the appellant had acted dishonestly in what he'd recorded in his notes.
Your submission has to go further, does it not? You have to submit that it wasn't open to the committee to find that he had acted dishonestly.
My lord.
Well, on what basis do you contend that it wasn't open to the committee so to find?
On the basis that insofar as he said what examination he had carried out and recorded what he believed he had done, to a certain extent, that he had, and or the extent to which Miss Page, the young lady concerned, believed that he hadn't carried those things out because she hadn't seen him do them, that there was scope for there to be, if you like, it was a finely tuned balance, it seems to me, for the panel, for the committee to have concluded absolutely that he had simply...
The fact that there is a finely balanced decision to be made because it comes to in a position adverse to your client doesn't mean that that was not a decision that was open to the committee. Right, well, let's see how we proceed from there then.
The way that I've finalised it really is in paragraph 58. I said the committee might well have concluded that the appellant did genuinely believe that he had done sufficient and or recorded sufficiently accurately to discharge his professional obligations. Now, where we go from there really is about the sort of general record-keeping approach that he had taken. And in this regard, I did want to just say a very few words about the circumstances that the appellant was in. It's right to say that he hadn't been in practice for quite some time.
No.
And in my submission, that would have been very obvious from any reading of the CV. And so the extent to which it's suggested that he was plainly very experienced and much should have been expected of him, in my submission, that is not a fair...
Well, I think that the case is made that he's highly qualified, but not necessarily having current experience. It's a position, isn't it? Yeah.
So qualified but not experienced and very little hands-on experience. And he spoke of himself having had a bit of a struggle getting up to speed with what the standards were for things like record keeping and how much detail and so on and so forth. And it is in that context that for example, criticised for using a templating approach where he cuts and pastes from other notes, and of course there are concerns around that, but in good practice. But it seemed to me that the committee failed to engage with the fact that whilst he was qualified, he hadn't got as much experience of actually being in practice, and therefore in judging him for his approach to note record keeping and the accuracy of those record keepings could well have been as much lack of competence as it was a lack of, and I say lack of competence,
honesty.
lack of experience.
Forgive me if this is a confrontational question, but how much experience do you need to have to make sure that if you cut and paste notes, you have to make sure that that reflects your views on the current case rather than simply duplicating or replicating notes that were made previously? Does that require much in the way of experience?
No, I don't think it does. But I think that when being judged for it, whether it's lack of competence or whether it's a lack of honesty,
Yes.
that's the distinction.
Right. Right.
Thank you very much. Those are essentially my submissions I wish to make to you orally, unless there are any other matters that you would like me to address with you.
Thank you very much indeed, Ms. Brown. Very clear. Thank you. Mr. Bradley.
Lords, I respectfully propose to address the matters which my learned friend has dealt with before your lordships.
Yes, that's very sensible.
Everything else is in my case, which I know your lordships have read. I preface what I say with what I suspect might be an unnecessary remark, but we are dealing with decisions of fact by this committee, and my Lord Kerr has already made observations about the context in which that exercise is to be undertaken, and I can't imagine I can assist your lordships any further with the legal framework for the exercise your lordship is now undertaking. And so, my Lord, I deal first with Lucy Allen. And I am going to respectfully suggest to your lordships that the way in which the college's case, the respondent's case in relation to Lucy Allen has been addressed before your lordships is not entirely accurate. And in order to do that, may I start by going back to the notice of inquiry which your lordships have seen. It's at EB page, starts at EB page 601.
And where is that in the hard copy?
It is it's in part 1 of the record.
70.
At the very front, divider 1. Section 1. I'm sorry, Lord, I did in fact switch everything to EB.
Well, I can work off these.
You can't win on this.
Yeah.
I'm very sorry. So
It was very wise as far as I'm concerned.
What's the EV number?
the EB
601.
is 601. It's that part of the record, and I understand it to be section 1, which contains all of the documents which...
This is a letter of the 1st of March, the notice of inquiry, yes.
Yeah.
It's the section of the bundle which has all of the notes, all of the written statements.
Right.
I'm sorry.
That's all right. No, that's all right.
And 4, head of charge 4 is Lucy Allen, and she's over the page on EB 602. And my lords will see that the first failure, A, is to undertake adequate examinations and investigation. Then, very closely connected, B, perform the TPLO with insufficient clinical justification. Now, my lords, all of the low friend submissions went to those particulars, to this head chart. And so, the remaining particulars have not been addressed head on. And the dishonesty particular is at E on the same page. And it has no connection whatsoever with the involvement of any other veterinary surgeons, any confusion about the dates on the radiographs. It is a very different allegation, and my lords will have seen the factual surgeon who undertook the provision opened this joint up and found that all of the soft tissue structures were in place and intact when the appellant had made a record that the opposite was the case. They were damaged and removed.
Your point is that this was central to the charge of dishonesty, and that the clinical records paint a wholly misleading picture as to the actual situation encountered. Yeah.
And this committee, as it was fully entitled to do, accepted the evidence of Mr. Farrell, who was the specialist orthopaedic surgeon who had undertaken the revision surgery, who expressed enormous surprise having read these records, expecting there to be no soft tissue structures on the inside of the joint, and expecting to have to rebuild the knee, found them all in place, and save for adjusting the angle of the bone.
May I just ask, what are these various elements? Performing an arthrotomy, finding a partial tear of the ACL and removing the meniscal tissue. Are they all aspects of what would have been the TPLO surgery?
Yes. So those are aspects of TPLO. The arthrotomy is dealing with the cutting of the bone into the joint. The partial tear of the anterior cruciate ligament, that is one of the ligaments in the joint. We have them too, obviously, and they join the thigh to below. And the meniscal tissue is the joint, is the tissue soft
Sorry,
tissue
mate.
lines. Oh, I'm sorry, I've moved. I was in...
Yeah, yes.
Does this mean the operation had been half done, or...?
It means it had not been done. So Mr. Farrell's finding was that all of these things which this appellant had recorded he had removed were present. They were there.
And on top of that, what was in fact done in the TPLO surgery was not done properly.
And on top of that, and that's the previous, that's the head of charge at C. So what was done, so there are two aspects to it. There's what you do inside the knee joint. You open the joint and you find the soft tissues. Having addressed that, I don't know the order in which it's done, but that's one part of it. The other is to adjust the angle. So you're, with a circular saw in effect, slicing off the top of the bone to change the angle on the tibia, and you then in fact rotate the bit you've sawn off, so you're creating a new angle, because this knee no longer has any ligaments, and ligaments hold the bones together, and you change the angle of the bones so that they can stay together without the ligaments. Now, so what Mr. Farrell found, Mr. Farrell's evidence is accepted by the disciplinary
This is set out in paragraph 53 of the decision, isn't it? Could we have a look
Of
at
course,
that?
of course we can. And my lords will find the findings of fact EB11 to start. That's where it starts. And that paragraph, which my lord identifies, is on EB27. And now, my lord, I'm in different parts of the record.
Well, it's under the first tab of the record.
Very
tab
good.
of decision.
I'm very grateful.
I've got it.
I see your lordships have
And
it.
page 17, and it sets out what Mr. Farrell said.
Yes. And your lordships see there, technically as bad as I've ever seen, post-operative x-rays are the type of x-ray that would make an orthopaedic surgeon gasp. Should not have been carried out in the first place. That goes back to 4A and 4B, of course. What I found during my surgery, it was not possible that what the original surgeon, the appellant, had written could have been true. Cranial cruciate ligament was complete and normal. The menisci were intact and normal, and I considered it extremely unlikely that the joint had been entered, because there would have been some changes visible to exploring the joint. Also demonstrated that the original surgeon could not have observed what he reported in his clinical history. Had I not carried out the revision surgery, Lucy would have been permanently disabled. So,
There was, the following paragraph, there does appear to have been some confusion about the radiograph on 21st.
Lord, may I deal with that? Because respectfully, I simply don't accept that the word confusion can be applied to this radiograph.
There was a... is there a difference in a radiograph and an X-ray or no?
They're completely interchangeable.
Yes.
But, my lord...
Could you give us the chronology?
Of course.
Yes.
Because it's... and then support it by taking us to the documents,
Yes, absolutely.
as far as it's necessary.
Yes. Can I ask your lordships, please, to go within the same bundle as the notice of inquiry, please? Can I ask your lordships to find EB 655, and if there are numbers with dashes in them, it's 247, bottom right. I don't think your lordships have those either. It's EB 655. It's Exhibit PRC 8. So an exhibit to Mr. Cooper's report, witness statement.
Forgive me, just give me that reference again, please.
EB 655.
Thank you.
And it's 247 in our
It
record.
It is.
Divider 5 inquiry bundle.
247.
Yeah, okay.
So what my lords are looking at here are the clinical records. You see the name Mr. Paul Allen at the top as the owner and Lucy just underneath the redacted address. And so that's what your lordships are looking at here. And if I could ask your lordships to go over the page, so to EB 656 or 2-48.
Yes.
Lordships will see at the in the bottom third of that page, the date the 2nd of December, 2015. TM, there's reference in the papers to Tom McNaughton. He's one of the vets at the practice. And you see at the bottom clinical notes, in the last section of that note, still lame, left hind. And reference to some instability on cranial draw test. And that's all about stretching the ligament to see whether it's lax or tight. And then at the bottom, please, admit for x-rays of both stifles to compare stifle instability. Stifle is the knee. On the following page, please, 249 or EB 657, just below the halfway point on the page, clinical notes start with the word SED, sedation, so sedate the animal for the radiographs. Palpation of legs reveal no significant cranial draw, but definitely some rotational instability. And then, my lords, will see this lateral radiographs of stifles showing cranial displacement of tibia in relation to femur, no significant osteoarthritic change, and then caudal views of the stifles showing patellae seated in groove, no significant osteoarthritic change, moderate tibial deviation. So those are the x-rays, and they were taken on the 2nd of December. Now, the records that follow, if your lordships go over the page again, please, EB 658. Lucy was back in on the 4th of December, just above midpoint on the page. Telephone call, and Lucy appeared to be a bit better, walking again. And things drag on for Lucy until, if your lordships then go to 659, EB 659, so 251. Lordships have that 2/3 of the way down the page. Last entry, 12th of December now, 2015. Back with Mr. McNaughton, so a consultation. So Lucy was brought in again and is given some medications. And one of the points Professor Comerford was making about this was the on-off nature of these problems, which nobody appears to have fully got to grips with. EB 660, please, 2-52. 18th of December.
Sorry, 650.
Yes, please, 660, I'm sorry, 660.
Yeah.
Halfway down the page, 18th of December. Now seeing a different veterinary surgeon, Catherine Barnes, and here, my lords, we'll see in the clinical notes, presented worsening right hind limb, lameness after jumping out of the car, now not happy to put out the leg down. Then underneath that, please, clinical examination, slight toe touching, very uncomfortable on it today, able to palpate the tibia, is thrusted forward. Previously mentioned no cranial draw instability, but couldn't say that now. Ongoing issue, owner doesn't want referral, and so on. So there wasn't in fact a diagnosis of a rupture, or at least no diagnosis was recorded in that note. And if your lordships then go, please, to the next page, EB 661-253, halfway down the page, please, 22nd of December, same veterinary surgeon, KB, Catherine Barnes. Clinical notes in 3 blocks. And in the second line, still toe touching with right hind limb, marked cranial draw. No recorded diagnosis of a ruptured cruciate ligament, but in that final block of 3, owner frustrated, Lucy isn't getting better, discussed referral options. And in the second line, my lords, explained if there is no surgery, then it's strictly resting her and non-steroidal anti-inflammatory drugs. Again, no written diagnosis of a ruptured cruciate ligament, but it is a fair assumption, and Professor Comerford, the respondent's expert, made it, is that that's what they were considering in there. And then finally, please, on this page, at the very bottom, BH is the, if your lordship see that, the same day, 3 lines down in the next block. Vet nurse, BH, and it's not a consultation, it's administration. And BH records in the clinical notes, spoke to owner in depth. And then at the bottom, Paul suggested that Peter Haggis, vet in Worthing, might be worth contacting, and now, my lords, recruciate repair has been cheaper than other referrals in the past. So that is a record, it would, on its face, that Mr. Paul Cooper has made that suggestion, but it is a record of no more than that, and it is a record of BH speaking to the patient.
You accept that it appears that Paul Cooper had by this time suggested this operation?
Yes, because, and it does say contacting re-cruciate repair. Now, there are many different ways of repairing a cruciate ligament. The appellant himself mentioned a number of them in his documents. There's over the top, there's TPO, and there is TPLO, which is what was done here. So certainly cruciate repair has been considered, but there's no suggestion, there's no identification of any particular means by which that might be done. And then with the chronology, again, please, over the page, 254.
Sorry, we were talking about a radiograph on the 21st of December.
My Lord's quite right. There was no radiograph.
That's what I
on
thought.
December. And
That's what I said, there was confusion.
well,
There seems to be a confusion.
what has happened?
There was one on the 2nd of December.
The only one was on the 2nd of December, pre-operative.
Yeah.
And what has happened, and I can take your Lordships to the transcript that your Lordships may not need, because it's the consequences that counts, not actually what happened, is in cross-examining the appellant, instead of saying the 2nd, the written transcription has me saying the 21st.
Ah, so it's your...
It's down to me, and I haven't asked to hear the tape, but the transcription says the 21st. So somehow, when asking questions, I have said the 21st. But it is of no significance because, other than that radiograph of the 2nd, there was no other preoperative radiograph.
Yep.
And that is the point, which is why I took the Lordships to 4A and 4B again at the beginning of these submissions. The point is a failure to carry out adequate preoperative investigation and assessment. And the only radiograph, as everybody sitting in the room in this case knew, was the 2nd of December. So it creeps in from me, the 21st. Yes. Everybody knows there wasn't one.
Well, let's leave that aside for the moment, because I think the position is tolerably clear.
Yes.
I mean, is your case that as of the 22nd of December 2018, what was being suggested was the possibility of a cruciate repair, or that it was being proposed that Peter Haggis, the vet working, the vet in Worthing, should be contacted in order to carry out a cruciate repair?
Well, the note says contacting Mr. Haggis re-cruciate repair.
Yeah.
And I cannot imagine Mr. Haggis, like any other veterinary surgeon, simply being told to do one. If you contact a veterinary surgeon re-cruciate repair, that veterinary surgeon is inevitably going to carry out their own examinations, as indeed this appellant accepted he was bound to do for himself.
It would have to be an investigation.
Of course.
That investigation, perforce, would require the carrying out of an X-ray.
For this operation, and Professor Comerford, the expert, criticised the appellant for not doing his own radiograph, because this is major surgery. It can have severe consequences for the animal, and it mustn't be done unless it's required. As I've explained, you're readjusting the joint in a very significant way. So all we have is that suggestion that there be a referral, and, my lords, that is entirely consistent with the next entry in the notes, please, 254 EB 662, which is the appellant's appointment on the 21st of January of 2016. And I ask your lordships, please, to take note of the purpose of this appointment. Under clinical notes, I hope your lordships will see the dog was brought in for a re-evaluation for RACL. This animal was not brought in for the operation. It was brought in for a re-evaluation.
Right.
And that re-evaluation was to be performed by the appellant who, as your lordships have seen, and I don't, I think, need to labour the point, as your lordships have seen, had told this practice he was an accomplished orthopaedic surgeon. And so when Mr. Cooper said, as he did, if your lordships were to go a few pages ahead, further forward in that same bundle, EB 617, old page 29.
Sorry, 617 or 671?
617, please.
Oh, page 2.
29, please.
29.
Yes?
This is the witness statement from Mr. Cooper, and your lordship will see the heading above paragraph 62, Lucy Allen, 6-year-old Bichon Frise, her owner Mrs. Allen, lady in her 80s. Before the appellant joined the practice, a previous vet at the practice, Tom McNaughton, had diagnosed that Lucy had a cruciate failure. That was the diagnosis, nothing more, which needed to be repaired. This was 2nd of December, and your lordships have seen the records. At that time, we knew that the appellant would be joining the practice, and given his prowess that we'd heard about in relation to orthopaedic surgery, Tom decided he would wait and let the appellant examine the patient, and if he agreed with the diagnosis, to book the surgery and carry it out.
Yes.
The point is made against the respondent that the involvement of these 3 veterinary surgeons was not brought sufficiently or brought at all to the attention of the disciplinary committee. Well, it was, because the disciplinary committee had the records. The disciplinary committee had all these statements. And the disciplinary committee had the expert report of Professor Comerford, in which, perhaps I just make the point rather than taking your lordship's
Yeah.
in which all of that history was set out. It was all summarised.
Just give us the reference.
It is on EB 1028 and old reference 13-5.
But in any event, presumably your submission is, if the committee had considered the records, it would have told them nothing other than that further investigation was required.
Absolutely. And as my learned friend has told your lordships, the appellant accepted that he ought to have done his own X-ray and that this operation proceeded without one.
I'm still quite confused as to what Mr. Farrell said had actually been done. I mean, in the passage we were looking before, did he say the operation hadn't in fact been done at all?
Yes. Yes.
So that,
Yes. So he couldn't even say the joint had been opened up because he expected to see signs in the structure that would indicate that there had been.
Well, there are various things that he would have seen. The arthrotomy, if that's the proper pronunciation of it,
Yes.
involves cutting into the joint.
Yes.
And that would have, if I've understood the situation correctly, that would have left an inevitable legacy, which would have been discernible. And when Mr. Farrell, examined the records and so on, there was no cutting into the joint visible at all. Likewise, no evidence of interference with the meniscus. Yeah.
None of it. And in fact, not only no evidence of interference, they were completely intact.
Yes.
So they hadn't been damaged in the first place.
It seems to me the gravamen of the charge against the appellant is that he purported to record that those procedures had been carried out, when in fact, on the subsequent evidence, they had not been.
Could you just show us the record where thank you.
Where that said.
Yeah.
Yes, I'm just going back. So if we go back to the timeline of the records, we're back to EB 662, so 2-54. And
EB 662, did you say?
I said we were on 662 EB.
Yes, thank you.
And on that page 254, my lords will see in the bottom of the page. So can I, perhaps just before leaving the 21st of January 2016, where I pointed out the re-evaluation for RACL, your lordship will see 4 lines down, right stifle with positive draw test equals RACL. So no suggestion that an X-ray had been made. It's a right stifle with positive draw test. That is the appellant's diagnosis, and that's the basis upon which it was made. The bottom half of the page, there's a new date now, please, the 4th of February 2016. And that is the beginning of the appointment, something like 2 weeks later. So the appellant's done his clinic, and he's done his investigations, he's made his diagnosis, he's decided what's going to happen, and the animal comes back in on the 4th of February 2016. And that record starts on 662, where there's a list of medications. And so I take your lordships to the top of 663, 2-55, where you see the 4th of February 2016 again. That's all about, there's some clinical notes there, but the operation note is the second half of this page. And then the first line of it is the dog was admitted in for TPLO. And the appellant has decided that that is what is to be done on the basis of his own assessment of the animal, limited though it was. And then, my lords, on the point under consideration, there is, in the fourth block of text, if I can call it that, there's an SX, which is symptoms. Mediolateral approach to the skin, open the joint mediolateral, irrigation of the joint, and then this, partial tear of ACL, anterior cruciate ligament, debrided the joint by the remained, presumably that's CLI, cruciate ligament, so debriding is taking it out, washed with saline, so that's the anterior cruciate ligament, and then lateral meniscus had a Y-shaped tear, it's not very clear in the copying, medial, so that's the meniscus, medial and cranial lateral meniscal ligament ruptured, meniscus removed. So the appellant claims there to have gone into the joint, identified damage to those structures, and removed them.
And you say that's just plumb wrong?
It's just plumb wrong, and my lord, I say that on the basis of Mr. Farrell's evidence.
The meniscus is the cartilage between two connecting joints, or at the joint between two connecting bones.
Yes.
And if the meniscus was removed, it would be, well, miraculous for it to be restored without...
Yes.
Yeah,
Yes.
and when it was opened up by Mr. Farrell, it was intact. That's your case.
Yes.
Yeah.
Absolutely. And the committee were completely, entirely entitled to accept Mr. Farrell's evidence.
Was there any challenge to his evidence of his clinical findings?
Well, the appellant did ask questions of Mr. Farrell and did ask whether he might be wrong, and did ask whether the meniscus, for example, could regenerate. And the answer to all those questions was no. So there was challenge to it. The appellant stuck by his evidence throughout that he did what he said he did, but the committee preferred the evidence of Mr. Farrell, and that it was, in my respectful submission, perfect.
Well, they deal with that at paragraph 55 of their decision.
So,
They
you
say
know-
why they preferred...
And I was finding Mr. Farrell's witness statement, but Lord, I don't think I need to see it because your Lordship clearly has paragraph 55 findings of fact in mind. I mean, his evidence was that this knee joint was normal. As I said earlier, he was expecting to perform some sort of reconstruction, And in fact, he told the committee all he had to do, because everything was normal inside the joint, was reverse the rotation of the bone which the appellant had undertaken.
Yes.
What happened to Lucy Allen in the end? Do we know?
I think to all intents and purposes, she recovered. So Mr. Farrell had said she would have been lame for life. Of course she would, no meniscus, and so on. But so far as everyone was aware, I think the records came to a bit of a stop.
Yes.
But she made good progress, as I understand it, after that operation, as I think Mr. Farrell expected she would.
Good.
Right.
So, the case was that the operation was done without any justification because the evidence available did not merit it, and the evidence available should have included an X-ray but did not. The appellant did shift in his evidence during the course of cross-examination to say he thought that an X-ray had been taken, but one was not, and the appellant ultimately accepted in his answer to my questions that must be the case. And my Lord, much criticism is made of the way the respondent handled this case, the appellant having been in person, but further inquiries were made of this practice to make sure there were no X-rays on that day. And my Lords can see that on the transcript. And so this was a grossly incompetently performed procedure, and what was put to the appellant in effect was that he tried to cover all that up by writing what he did in the records. And in essence, that's what the disciplinary committee accepted.
What do you say about the submission that this wasn't a decision that he made on his own and that other vets encouraged him to do it?
Well, Lord, I don't respectfully accept that submission at all. You've seen what the position was from the records, and so you've seen the gap between Mr. McNaughton's last visit, and you've seen what Lucy Allen was listed with the appellant for re-evaluation. And you've seen that Lucy was then listed for TPLO by the appellant. And so
just remind us of the references to that. I mean, I think your case is that those who saw Lucy Allen before the appellant considered her case had not expressed any final view that TPLO was necessary. Just remind us of the references to that, please.
Those are the clinical records.
Yes.
And so they are all in.
Well, you've taken us to them already.
Have you got that all right? Yeah.
From EB 655,
Yeah.
if I can put it.
Yeah.
Can I?
And your case is that doesn't absolve the appellant of the need to conduct proper investigations, because those were provisional views that were expressed. Is that right?
Whether or not provisional, and the records only say what they do say, and I do accept that the records show thinking, cruciate repair, but on no occasion is there any identification of TPLO.
No.
So nobody had decided before the appellant that this was for TPLO. And the notion that a veterinary surgeon can say to his regulator, well, I did this operation because other people told me I should, is, in my respectful submission, nonsense. The veterinary surgeon who performs a procedure, like a human medical man who performs a procedure, will take responsibility for his actions.
Well, he must be personally satisfied that the procedure that he's going to undertake is required.
Absolutely.
Yeah.
May I ask your lordships, please, to look at the transcript, EB 310, and my lords, we are now in that part of the case which contains documents resulting from the hearing rather than documents for the hearing, so all the transcripts. EB 310, I'm describing them very badly.
Day 446.
I'm very grateful. I'm very sorry I'm not doing very well with those page references.
Well, so long as you keep the electronic bundle reference,
We'll be able to find our way through.
that's very important.
Lord, EB 310 then, this is day 4 when I was cross-examining the appellant, and if your lordships look at the top of the page, we were looking perhaps at C, perhaps at B. The dog was brought in for a re-evaluation of RACL. Do you have that? That's my question. So we're looking at the records I showed you lordships a moment ago. Yes, the re-evaluation was to be carried out by you. Yes. So it's for you to decide what was wrong with Lucy and what treatment, if any, would be required. Yes. Nothing to do with anybody else's views about Lucy. You were the veterinary surgeon carrying out this re-evaluation. Yes. So it does not matter what Mr. Cooper thought, for example, does it? What Mr. Cooper told me, I had to take into consideration, have in mind. Question, you have it in mind, but, and then the answer, it's not his declaration. I have to make my, and I interrupted your own judgment, 100% always. So we can forget about Mr. Cooper, yes. And that must, quite apart from the fact that that's what the appellant was saying to the committee, that must be right.
Yes.
My lords, I do load onto that, without going through all the detail, you've seen it in my case, the facts that the appellant arrived in this country as a veterinary surgeon with experience and professing an understanding and ability with orthopaedic surgery. That's the evidence of Fiona Stevens at the practice. He even discussed orthopaedics with one of the other vets. He was interviewed, it's not right to say he wasn't. And this practice brought him in because of what he was saying about his orthopaedic ability. And it simply can't be right that an employer, and now this respondent is expected to draw conclusions from curriculum vitae, when it's what the veterinary surgeon himself was saying about what he could and couldn't do. My lord, also in my case, I'm doing this a lot, and I hope, I'm sure your lordships will tell me to show you the reference, but in my case I also set out a list of things which the appellant had said to the respondent and to the committee about his abilities. And so even at that stage, and there was one quotation where he even said that it's like riding a bicycle, so if you haven't ridden a bicycle for 6 years, you'll still be able to do it when you come back. So the suggestion now that your lordships must look at these findings of fact in the context of a veterinary surgeon who needed supervision cannot, in my submission, be at all sustainable.
Yes.
Could I just ask in that connection,
Yes, my lord.
in paragraph 23 of your case, paragraph A, you quote from a statement sent to the respondent on the 7th of August.
Yes.
I performed thousands of TPOs, you see appears in the middle of that passage. Is that the operation again that we're talking about here?
No.
It's a different operation.
So that there, as I said, there's a few ways of doing
I see.
TPOs is one. Over the top is another. And if your lordship allows me, can I ask your lordships to go to EB 986 is the reference I have. EB 986, 12-10 in the part of the bundle which has the witness statements and exhibits which the committee saw. EB 986. This is the appellant's letter to the respondent the 7th of August 2016, and 2,000 thirds of the way down the page, if my lord's got the page, is part A, and 1A is Lucy. And if I count 8 lines, 7 lines perhaps, I ended pronouncing TPLO, so the decision was TPLO, which was accepted. TPLO and over the top are my preferred techniques, which I have performed hundreds of times. So although TPO is different, it was in the quotation you saw, in fact, the respondents, the opponents claim, included.
Sorry, which page was that again?
12-10 or EB 986.
986, thank you.
Yes.
So context, in my respectful submission, does not help the appellant at all. And I say, as your lordships know, that these were findings of fact, which the committee were perfectly entitled. Now, my lords, I'm going to leave Lucy Allen there. That addresses the points raised orally by my friend, and I move then to 2 and 3. Charges 2 and 3, your Storm, Sanson, Page, and as your lordships know, the allegation here was no examination, but a record that an examination had taken place.
Yes.
My lords, the records, and I make these submissions in the context that the complaint is that these findings were made against the weight of the evidence on the basis of evidence which was demonstrably unreliable. The records are at EB 826 and EB 827. They would be 6-7 and 6-8, if that is a helpful reference, in the part of the record which contains all the statements and documents, so the inquiry bundle.
Yes.
And on 826 are the records for Storm, and on 827 are the records for Samson. They are identical, save for the weight, which you'll see in a moment. So 2nd of February 2016, the appellant's name as the veterinary surgeon, and then clinical notes, male admitted for routine castration, then the docket text, BAR is quite responsive, history nil, then objective, I think I know must be weight 3.6, and then a list. Weight 3.6 kilograms, mucous membrane pink, CRT is capillary refill time, less than 1.4 seconds, lymph nodes, ears, abdomen, musculoskeletal system, urogenital system, skin, coat, teeth, DUDE, all normal, body condition score is BCS 6 out of 9. The record for Sampson on 827 is the same, but the weight is 3.8. Now, those I suggested to the disciplinary committee, and the disciplinary committee accepted as it was entitled to, are records of full operative examination.
And they couldn't be carried out when the animal was sedated?
Correct. Lordship's absolutely right. And so the witness evidence, and perhaps I don't need then to take your Lordships there, but for your Lordship's record, it's EB 820, and doing it that way, well, in fact, I can give the other witness statement starts on 6-1 in the inquiry bundle. This was a veterinary nurse, as your Lordships know, employed at practice. The cats were with her all day because she was the cattery nurse. She took them in to see the appellant for the procedure, and her evidence was that there was no examination. And the reality, of course, is her evidence is also that the appellant told her to give the animals the pre-med, which is the initial medication which will make them sleepy. And if having pre-med was a bar to carrying out a full examination, clearly the appellant was never going to do an examination because he ordered the pre-med to be given, having not done such an examination. So the committee was, in my respectful submission, entitled to accept the evidence of this witness, the veterinary nurse, Ms. Page. They made an assessment of her and reported that in their judgment she was entirely credible. And they were absolutely entitled to accept her evidence that no examination was performed. In the respondent's own material, perhaps it's on EB 989, so 12-13, the letter of the 7th of August 2016 wrote to the respondent, EB 989, 12-13. We looked at an earlier part of this. First paragraph to begin on the page with a B in front of it with Storm and Sampson. Prior to surgery, they'd been prepared by Mrs. Page. Very briefly, I checked femoral pulse, lymph nodes, visually restoration for 10 seconds. The evidence was that he did that while inducing anaesthesia. That's an anaesthesia check. Check the membranes and the depth of the anaesthesia. Yes. I admit I did not do a full examination before the surgery because I did not have the chance. Usually I would refuse the surgery and postpone it. That is the point. The learned friend says, well, this was a veterinary nurse who knew they were healthy. It's not for the veterinary nurse to decide that. The appellant's duty was to perform a proper examination to ensure these animals were fit for anaesthesia before he subjected them to it. And so the committee is then faced with a veterinary nurse who knows what was and, more importantly, what was not done, and a very full record in the notes. And their finding, as your Lordships can see, was to accept the evidence of the nurse. Lords, I think that is what I say about Storm and Sampson. I just add this. There is another dishonesty charge in relation to Chino Biggs, another cat, which is head of charge 7. about which you were not addressed orally this morning. And I seek simply to say, in light of the fact that you've heard your submissions about it, the position is the same as it was. In effect, it's the same as it was for Storm and Sampson. Here, the owner brought the cat in, saw what happened and what did not happen, and the appellant made a record that an examination was carried out. In fact, his cross-examination, the committee in their determination call the cross-examination of this witness strong. The committee heard her stand up to that cross-examination. If I could take it's in the findings on fact, please. EB 18. 1818, my lord, please.
Thank you.
And this is the findings of fact. And so in the record, the part of the record which includes the transcripts, and at paragraph 19 and 20 of the findings of fact, Ms. Biggs was an experienced cat owner with high lay knowledge of client expectations, a veterinary surgeon dealing with cats at routine examinations. She was strongly challenged, and the appellant put to her that this simply didn't happen, and gave extremely clear and believable evidence regarding the extent of the respondent examination of her animal. The committee considered her a patently honest witness who had no reason to tell anything other than the truth. So I add those to the submissions I made in respect of heads of charge 2 and 3.
Yes.
Lord, those submissions cover the matters upon which my learned friend addressed your lordships orally this morning. And as I said at the outset of my submissions, I wouldn't stray outside the oral submissions, just as she limited her submissions. I, responding to this appeal, do the same. Your lordships have my case. In summary of it, the respondent's position is that all of the decisions which the committee made, both in terms of fact and judgment, were decisions it was absolutely entitled to make. I provided your lordship with the authorities which provide the framework to those questions of judgment. I know your lordship's seen those. It's very much a matter for the discretion of this tribunal, and given the findings it made about the appellant, both in terms of the facts and its judgment, that he was wholly lacking in insight as to his limitations, its conclusion was that the only proper means to protect animal welfare was his removal from the register.
Yes.
That they were entitled to conclude.
Nothing else?
Unless I can assist your lordships any further.
Thank you.
Yeah. Thank you very much. Now, Ms. Brown. Yes, by all means.
I'm so sorry.
My Lords, in responding to my learned friend's submissions, the first thing I've got to do is apologise, which is never a very good start. But that is because I failed to refer you to something that I should have referred.
Don't worry about that. Let's do it now.
Right. What I need to take you to is in connection with Lucy Allen, and it concerns a report produced by a Dr. Angus Anderson that is in your electronic bundle at page 1346, and the hard copy is at page 123 of the supplementary bundle.
Yes?
The background to this report is that it was commissioned by the respondents as an expert to give evidence about his expert view around the treatment and management of Lucy Allen. And at page 123, he set out a number of issues. And at page 124, under the heading of my observations and comments, he makes the point that he said there clearly had been concern that lameness was due to cranial cruciate ligament injury because another vet at the practice had diagnosed this problem prior to Dr. Elefterescu, the appellant, examining the dog, and he refers to the practice notes of the 22nd of December 2015 KB. He also goes on to say that the radiographs did not support this diagnosis, and he makes some observations about it. Towards the end of that same paragraph, Dr. Anderson, who was a specialist in small animals surgery, also says this. He says, it appears that cranial cruciate ligament injury was incorrectly diagnosed, especially in view of Mike Farrell's subsequent findings. In Dr. Elefterescu's defence, he was not the only vet in the practice to have made this error. And he also goes on to say that he states in his letter to the RCVS that Lucy had been examined by Mr. Cooper and that cranial cruciate ligament rupture had been suspected. He then goes on to say this. The problem with this diagnostic error is that surgery is indicated in most cases of cruciate ligament injury. Then Dr. Elefterescu then performed a TPLO and made some errors in its execution that subsequently meant it required revision. And he's asked the question, he answers the question, if Dr. Elefterescu genuinely believed Lucy had cruciate ligament injury, then performing a TPLO was an acceptable form of treatment and his conduct was acceptable.
Well, I mean, there are two criticisms made of your client in relation to this particular surgery, or two principal criticisms. The first is that an X-ray ought to have been performed. Now, do you, on the behalf of your client, dispute that an X-ray should have been performed? No. And the second major criticism is that the clinical records of the surgery were quite clearly erroneous. Go on.
Dr. Anderson did deal with that point in his report.
All right, okay.
What he says is this. It's on page 125. Talking about the difficulties and...
He talks firstly about the possibility that he didn't perform the osteotomy and falsified his clinical notes. Yes, and what are you going to...
And then I go to the point where he says, if Dr. Elefterescu falsified his clinical notes and did not perform an arthrotomy, his conduct would fall far below that of a reasonably competent vet.
Where are you reading?
I'm so sorry, my lord. It's at page 125 of the preliminary expert report that was produced by Dr. Anderson. And it's it's in bold, if Dr. Elefterescu falsified his clinical notes and did not perform an arthrotomy, his conduct would fall far below that of a reasonably competent vet. If, however, he misinterpreted his observations during the Stiffle surgery and trimmed tissues other than those described, cranial cruciate ligament and lateral meniscus, I suggest that his conduct is acceptable. Did he recognise his case was outside his area of competence? And he makes some observations about that. So there was, in this first report that had been commissioned by the respondent, another view as to the appellant's competence and his conduct in this matter, which did
Well,
not...
we're in the area of his honesty now, aren't we?
Yes, we are, which did not necessarily mean that he had been dishonest. It may be that it was simply a matter of competence. He says...
well, I'm slightly lost to understand how it can be confined to an area of competence. Either he did carry out the arthrotomy and the meniscal surgery, or he didn't.
What Mr. Anderson said about that
Yes.
was that he said, the question is it possible to reconcile the observations of Mr. Farrell made at revision surgery with the notes made by Dr. Elefterescu regarding the trimming of the cranial luciate ligament and the lateral meniscus? He says there are clearly several possibilities. Firstly, Dr. Elefterescu did not perform an arthrotomy and has falsified his clinical notes. Secondly, his observations made during surgery were incorrect, and he trimmed tissues that were not the cranial cruciate ligament or lateral meniscus. And he says, in a very small joint, it may be very difficult to tell with certainty whether an arthrotomy has been performed previously, but Mr. Farrell is a very experienced surgeon, and it would appear that the cranial cruciate ligament and lateral meniscus had not been, I think it should be, interfered with surgically. And then he says it is possible that Dr. Elefterescu trimmed other tissues, but a surgeon with a reasonable amount of experience of stifle surgery would not normally make such an error. And then we have the next point. So suffice to say that not having done anything at all and being deliberately dishonest about it was not the inevitable conclusion to take.
Right, well, I can see that, but can it be disputed that it was a possible conclusion?
No, my lord. But it would have been fairer in the scheme of things if the committee had been aware that Mr. Farrell's view of the matter was not so absolute, not so irresistible, that the only possible conclusion to follow must be that the appellant had been dishonest.
But your client had this report, didn't he?
It was served as unused material.
And he could have relied on it, but didn't.
Could have relied on it. He was not legally represented.
But he may not have wanted to rely on it, because it doesn't give a very favourable view of his competence.
He may not have. I haven't asked that question, and I don't think it was a
But
question.
we can't speculate.
No.
No.
The
But
fact was, he had it, could have relied on it. The committee had it as unused material.
Well, did the committee have it?
Or maybe they didn't.
No.
they
No, they
didn't
didn't.
have it as
No, I see. No, I just decided to put it in front of him.
But presumably your client was asked whether or not he actually carried out these various aspects of the procedure recorded in the notes.
Yes, he did.
He was asked about that.
He was asked
And
about
and his response was that
And his response was that he had.
That he had done them.
That he had done them.
Yes.
Very briefly, day 4, page 51. Thank you. This perhaps sort of answers two questions at once. First of all, we again have this reference, halfway down the page, between D and F, there are some questions that were put to the appellant specifically on this issue. First of
Do you have an EB number, please?
Thank you.
Sorry? 315, thank you.
This is 451. Yeah.
Yes? Yes, do continue, Ms.
Thank you,
Mohammed.
my Lord. Question. Their reading of the X-ray, that X-ray of the 12th and 18th of December 2015, was entirely consistent with what Mr. Farrell says he found when he opened the joint. In other words, entirely normal ligaments. Pausing just for a moment, I haven't listed the number of occasions when this misunderstanding arose, but there we see again this reference to this X-ray. However, in terms of this point, what was it that the appellant said? He said, Yes, in this situation, between the femoral, condyle and tibial plateau in the lateral site was a formation. What kind of formation, organ or tissue can be there? Only a meniscus. Even though I don't know any anatomy, if something is between bony surfaces that one is removed and nothing remained there, what can be? I asked Mrs. Professor, what can be between the two joint surfaces? Only a meniscus. I removed that part. I put on top of the drape and I asked the nurse to come and take pictures. Pausing again, my lords, that's the reference I referred you to about photographs. Because for me it was an unexpected case and a completely new one, because the damage of the lateral meniscus is recorded to be less than most of the cases. So his response, I fully accept, is that he was convinced that he had removed it.
This picture that the nurse took, that was never produced.
The picture that the nurse took was never produced.
Mm-hmm.
But in fairness, he had referred, before I say that, I should just check.
Yes?
But I was just checking to see whether when there had been an early reference to the fact of photographs having been taken when the appellant was first asked to give an account of his dealings with the animal. I'll move on quickly. So that's I just wished to draw attention to that there was another view in respect of that. And then finally, two other points, just in terms of the evidence of Miss Page in respect of Sampson and Storm. You have been taken to the nurse's evidence, and I just thought it was important to note that in giving her evidence, Miss Page had explained that her concern, she actually confirmed that she had in fact given the animals the pre-med herself, and in her evidence she also confirms that they were fit to have the surgery carried out. So we have this tension between her having taken, and she also confirmed in her view she should have written the notes. So there was a tension between if you like, what had been content to have been done on the day, which was outwith practice, and yet also to be critical of the appellant for then having undertaken steps which were within. And finally, in respect of Chino Biggs, I didn't make oral submissions, but you will find my observations about that at paragraph 57 of my written case. Thank you very much.
Thank you very much.
I mean, we've got all the other complaints, some of which were found, some of which were admitted. I mean, one of the ones that was admitted was Kitty Brown, the first one, where he simply failed to check whether the sex of the animal before cutting. I mean, that seems pretty strong, doesn't it?
Interestingly, in regard to that, my lord, that was not a matter which the committee went on to find did fall below the requisite standards, on the basis that the appellant was not the only vet to have made the error about the gender of the cat.
As a lay person, that would seem something which was very basic. But anyway, there we are. It's not part of the substance of the case, I believe.
But he wasn't alone in having done that.
I see. Okay, well, it may be more difficult. Yeah.
Thank you very much indeed. Now, Mr. Bradley.
I'm sorry.
Yes, no, we were going to invite you to comment on, is it Mr. Anderson's evidence?
Lord, I'm not going to say very much about it. My point about it would be, in fact, having regard to the evidence that was given, it makes no difference whatsoever. It's an expression of opinion on matters which were for the committee to determine. So one way or the other, it adds little or nothing, but more substance. May I just ask your lordships to take note of EB 326, which is transcript day 4, page 62.
EP3.
EP326.
Thank you.
Yes?
Because I, in fact, raised the very possibility that there'd been a misunderstanding with the appellant. So at D, I put it to the appellant, he didn't remove the menisci, and he said, I removed the lateral meniscus. Mr. Farrell opened the joint, it was still there. And then I asked for CT because I know what I removed. And then I said at E, it may have been a piece of tissue, but it wasn't meniscus, was it? In your opinion, but in my opinion, I know what I've done. And if your lordships go to G, I said, or was it a bit of intrapatellar fat? It's impossible. Fat is fat. So the possibility that he misinterpreted what he was doing was expressly put to him, and he expressly rejected it.
Yes.
Lords, unless I can assist your lordships any further.
Thank you very much indeed. We're very grateful to Council for their very helpful written and oral submissions in what is, of course, a very important case for the appellant and also for the respondent. The Board will take time to consider what advice they will humbly tender to Her Majesty, and in the meantime the Court is adjourned.